All right, well, I'd like to begin today's webinar by acknowledging on behalf of Your Story Disability Legal Support and Queensland Advocacy for Inclusion, acknowledge the Turrbal and Yagara people as First Nations custodians of the land where we're hosting this webinar today. And we pay our respects to their elders, laws, customs and creation spirits. And we extend our respects to First Nations people participating today. Before we begin, I'll just give a brief summary of the webinar today. We're going to start with the main part of the webinar with a presentation by Dayne Kingsford from Queensland Advocacy for Inclusion. We'll then have a short segment on the Disability Royal Commission and Your Story Disability Legal Support, and then we'll be followed then by some questions and answers. Some housekeeping. The webinar today is being recorded as well as live streamed to Facebook, and Auslan captions are also available. To turn on your captions, please go to the toolbar at the bottom of your screen and click on the button labelled CC Live Transcript, and then select Show Captions. Please post in the chat if you're having any technical issues. For questions on Zoom, please use the Q&A function to ask questions. Please don't use the chat function. You can ask a question anonymously if you wish to. And on Facebook, please post your questions in comments. If we don't get to your question today during the webinar, we will respond to you via email or Facebook, depending on how you're joining us today. Just an important legal reminder too about participating in today's webinar. There are laws in each state and territory of Australia restricting information about guardianship proceedings, which may affect how you share your story with the Disability Royal Commission. The laws vary from each state and territory, and that's why we recommend that you speak to a lawyer from Your Story Disability Legal Support to get advice about your own situation and safe ways to share your story. But very importantly for today's webinar, please do not disclose any personal information about a person under a guardianship order or has previously been involved in guardianship proceedings in your questions or during the webinar. And finally, if the webinar raises any concerns for you today, free counselling is available. You can call Blue Knot on 1800 421 468. And the details will be shared on chat and on Facebook. I'd like now to introduce Dayne. Dayne Kingsford is a Principal Solicitor at Queensland Advocacy Inclusion's Human Rights Advocacy Practice, where he's worked since 2020. Dayne assists people in the areas of disability discrimination, human rights and guardianship and administration. Prior to joining QAI, Dayne worked and volunteered at a range of organisations, including community legal centres, not-for-profits, and also in commercial practice. Dayne has a passion for protecting the rights of vulnerable community members. So now I will hand over to Dayne to lead the presentation on guardianship and administration in Queensland.
Excellent. Thank you very much, Steve, and good afternoon, everyone. I hope my screen, everyone can see the presentation on the side. As Steve mentioned, my name's Dayne. I'm a Principal Solicitor at QAI, and I would first like to also acknowledge the traditional owners on the lands and which we're meeting today. For me, that's the Yagara and the Turrbal people. I'd like to pay my respects to their elders past and present. I would also like to pay my respect to any Aboriginal or Torres Strait Islander people who may be joining us today. As we are discussing guardianship and administration, I would also like to acknowledge the significant impact that substitute decision-making has on the right to self-determination of First Nations people with disability. So before we get started, I thought I might just do a quick overview of QAI. For those who may not know, we're an independent, community-based systems and individual advocacy organisation and a community legal service for people with disability in Queensland. Our mission is to promote, protect and defend through systems and individual advocacy the fundamental needs and rights of the most vulnerable people with disability in Queensland. QAI has over 30 years experience in advocating for systemic change through campaigns directed to attitudinal, law and policy reform by support the development of a range of advocacy initiatives in this state and nationally. We also provide specialist legal and non-legal advocacy services in our mental health, NDIS, disability and human rights advocacy practices. We provide a comprehensive mental health and human rights legal service, a justice support service, NDIS appeals and decision support, education and young people's advocacy, as well as Disability Royal Commission advocacy support. So here's a quick overview of today's presentation that we'll be discussing. As Steve mentioned, I have about 30 minutes with you all, and then we'll go to some Q&A. The topics that we'll discuss today include an overview of the Guardianship and Administration Act, which I will just call from here on most likely the Act, the Act's general principles, the Act and capacity, how guardianship and administration orders are made, who may be appointed as a guardian or administrator, reviews of those orders, guardianship and administration proceedings, including some limitation orders that include like confidentiality orders, for example, as well as alternatives under the Act for the appointment, of a guardian and administrator. So the Act was created in response to the Queensland Law Reforms Commission's report in 1996, assisted and substitute decision-making for people, decision-making by and for people with decision-making disability. Ultimately, the Act provides for the appointment of a guardian and or an administrator for adults who don't have capacity to make decisions in circumstances where there's a risk to the adult. Before we discuss those concepts further, I thought I might raise a few key points. Firstly, when I speak about the adult, I mean the person who is subject to the guardianship and administration application or the order. An administrator is a financial decision maker, and a guardian is a personal decision maker. So the Act covers a range of general topics, which I've summarised on the screen for everyone, but it includes the general principles, the appointment of guardians and administrators, changing appointments, functions of guardians and administrators, QCAT proceedings, which is the Queensland Civil and Administrative Tribunal, and the creation of the Office of the Public Advocate. Turning now to the 10 general principles that are within the Act, and these must be applied by a person or entity performing a function or exercising a power under the Act. So that includes a guardian, an administrator, and QCAT. They're all summarised on the screen there for everyone, but it includes, the first is that there's a presumption that all adults have capacity for a matter. Secondly, that the rights of all adults to the same human rights and fundamental freedoms must be recognised and taken into account. Thirdly, empowering the adult to exercise those human rights and freedoms, maintaining the adult's existing supportive relationships, as well as their cultural and linguistic environment and values. The sixth general principle relates to respect for privacy, followed by the adult's right to liberty and security on an equal basis. The ninth general principle relates to a person or entity when performing a function or exercising a power under the Act in relation to the adult, doing so in a way that promotes and safeguards the adult's rights, interests, and opportunities in the least restrictive way. The 10th general principle relates to structured decision-making. A key concept that is discussed within the Act and working with it is this idea of capacity. It has different meanings for everyone. And as I mentioned, the first general principle relates to the adult having a presumption of capacity. When we're talking about capacity with the Act, it has a specific meaning, which I've copied on the slides, and that is that the adult is capable of understanding the nature and effect of the decision, making the decision freely and voluntarily, as well as being able to communicate that decision in some way. When an adult has capacity, they're able to understand and retain information, even if it's for a short period of time, relating to the particular decision. They can understand the main available options and choose them, and understand and consider consequences of the potential choices. It's also important to note that the idea of capacity is time, domain, and decision specific. Unlike other pieces of legislation that people might be aware of, like the Mental Health Act, there's no provision within it that allows for fluctuating capacity. So when the QCAT is considering an application, which we will discuss soon, the relevant time is the present that they must be assessing the person's capacity. Evidence that one of the three criteria for capacity may not have previously been satisfied would be of limited value, particularly in instances where there's either no positive evidence that the adult currently lacks capacity. On screen, and that will be shared with everyone as well, are two really helpful documents, I think, for anyone interested in this and who might engage with capacity, for example. The first to the left is the Queensland Capacity Assessment Guidelines that were produced in 2020. These guidelines provide general information about capacity assessments and the legal tests within Queensland, and they're relevant to guardianship legislation. So that includes the Guardianship and Administration Act, but also the Power of Attorney Act. And they only apply when assessing capacity of adults, so people who are aged over 18. The second document, and to the right of the screen, is the Queensland Handbook for Practitioners on Legal Capacity. It's a bit more specific, but it still provides some good ideas and context around capacity. It's a handbook that Queensland lawyers can use as a sound conceptual framework for assessing whether or not their client has capacity to give legal instructions. It details various steps that a lawyer can take in assessing their client's capacity. Moving now to how a guardianship and administration order might come about. A person, the tribunal, QCAT, can make an order appointing a guardian or an administrator on its own initiative or by application either by the adult, the public guardian, or an interested person. The term interested person within the Act has a specific meaning. It's quite broad. It says that a person who has a sufficient and genuine concern for the rights and interests of the adult. As you could imagine, this leaves a bit of scope for a number of people involved in the adult's life to potentially make an application for the appointment of a guardian or administrator. Moving now to the application of how orders are made, it provides that the Act provides, that an order may be made. So the QCAT has discretion whether or not it does make an order to appoint a guardian for a financial matter, or a guardian for a personal matter, or an administrator for a financial matter for an adult if it is satisfied that the three criteria that I've summarized on the screen are satisfied. So that is that the adult has impaired capacity for the matter, there is a need for a decision in relation to the matter, or the adult is likely to do something in relation to the matter that involves or could involve a level of unreasonable risk to the adult's health, welfare, and property. And finally, that without the appointment of a guardian or administrator, the adult's needs won't be adequately met or their interests won't be adequately protected. Talking about these criteria is a more substantive order. However, under the Act, QCAT's also empowered to make what's known as an interim order, which are short-term orders. They can go for a maximum of 3 months. They can be extended or remade for a further 3 months if there is an exceptional circumstance to justify that renewal. The test is slightly different to what we just discussed. That is that the tribunal is satisfied on reasonable grounds that the adult concerned has or may have impaired capacity for a matter, and that there's an immediate risk of harm to the health, welfare, or property of the adult, including because of risk of abuse, exploitation, neglect, or by self-neglect by the adult. These applications are also slightly different in that they allow the tribunal to make them on the papers or without a hearing. So they will make the determination based on the information that it has in front of it. It also empowers the tribunal to make these orders without complying with certain requirements under the Act, including by giving notice to the adult, for example. In addition to capacity, there's also discussion around different types of matters. The Act provides for 4 different types of matters, and I've copied them on the screen. That is that there's personal matters, and so that can include things like where the adult lives, what services they might receive, such as the NDIS. There are special personal matters, such as making or revoking a will, consenting to marriage, special health matters, such as sterilisation, and then also financial matters that include things like payment of the adult's debts. Moving now to the hearing itself and the tribunal, QCAT having an application in front of it, it's satisfied now that the 3 criteria we discussed previously are met and that it's going to appoint a guardian or an administrator for an adult. In doing so, the tribunal has to consider what is known as the appropriateness considerations within the Act. Again, I've summarised them on the slide, and that includes whether or not the proposed appointee will apply the general principles that we discussed at the beginning of the presentation, whether or not the adult and the proposed appointee's interests are likely to conflict, whether or not they are compatible in terms of communication skills, appropriate cultural and social experiences and knowledge, whether or not the person is available and accessible to the adult, whether or not the person is appropriate and competent to perform the role and functions and exercise powers under the appointment. The tribunal will also consider any prior removals of that person, any refusals, any relevant criminal history, and any bankruptcy. In addition to satisfying the appropriateness considerations, anyone appointed to that role must be at least 18 years old. They can't be a paid carer or health provider for the adult. And it's also noted in the Act that the appointment of the public guardian, which is one of the statutory entities, is the appointment of last resort. So anyone who satisfies all the criteria we just mentioned should really be appointed in place of or instead of the public guardian if available. Once the person has been appointed as either a guardian or administrator, they are empowered to do anything in relation to the matter that they've been appointed for that the adult could do. So, for example, sign a tenancy agreement or pay a person's debts. They must apply the general principles which were discussed at the beginning of the presentation. They must act honestly and with reasonable diligence. And they must avoid conflicts of interest, keep records, keep property separate, and they're also entitled to reimbursement of reasonable expenses incurred in performing that role. Once an order has been made, there is provision within the Act for it to be reviewed. The Act says that it must be reviewed at least every 5 years. So it's a maximum term of 5 years before the tribunal should consider it again. However, that doesn't mean that that will be the one and only length of appointment. It can vary depending on the circumstances. However, this rule doesn't apply to the appointment of the public trustee as an administrator for the adult. If someone is subject to a guardianship and administration order and they're hoping to either have it reviewed, to amend it, being the length of the appointment, who is appointed under the order, what decisions the person is appointed for, they might wish to consider applying using the Form 10, which is on the left, which is the same form used for the original appointment. If the person is hoping to get a declaration that they have capacity, which would then revoke the order in turn, they can consider using the Form 11, which is on the right. However, it's always best to speak with a lawyer before taking such action, just to make sure that you're on the right track. If a person under the order hopes to have it reviewed, as I said, outside of, say, the 5-year period listed in the order, there's what's known as a practice direction, or basically a rule for QCAT, that an order can't be reviewed outside of that date within the order, so the 5 years, unless there is new and relevant information, there's been a change in circumstances, the appointee is no longer competent, or a person has become more appropriate for that appointment. So again, a person's considering whether or not to apply for a review should speak to a lawyer about the best option and how they might go about applying for that review. If you're now at either the review or the appointment, there's what's known as active parties, and they have the right to appear before the tribunal in the matter and be given a reasonable opportunity to present their case. The Act provides a list of who is considered to be active parties, and that includes the adult, the applicant, if it's not the adult, any proposed or current guardians or administrators, the public guardian, which is a statutory entity who can be a guardian, or the public trustee, which is another statutory entity which can be appointed as an administrator for the adult. Active parties can also include any other person that the tribunal considers relevant and join to the proceedings. Ahead of a proceeding, the Act says that the tribunal has to give at least 7 days notice before the hearing. In conducting a review, it's empowered to do it in a way that it considers appropriate. It's not bound by the rules of evidence like a court might be, and it's inquisitorial in nature, meaning that it will ask the questions of the active parties, for example, or anyone else involved in the hearing to obtain the information and evidence it needs to make the order or make the decision. If it's a review, at the end of the review, QCAT must revoke the order unless it's satisfied that it would make the appointment if it were a new application. So going back to the 3 criteria we discussed a little earlier on in making an original order. In conducting reviews and hearings, QCAT is also a public entity under the Human Rights Act. So in addition to complying with the Guardianship and Administration Act, the general principles, it's also bound to consider the human rights that are listed within the Human Rights Act. It's also important to note that there's no guaranteed right to representation by a lawyer at QCAT proceedings. As Steve had indicated at the beginning of this presentation, there are strict confidentiality and publication orders around QCAT proceedings for guardianship and administration. There's a general rule that information may be published about proceedings. However, it cannot be published without reasonable excuse. Any information that might likely lead to the identity of the relevant adult to the public or a section of the public without a reasonable excuse. In addition to this general position, the Act provides for 4 limitation orders, which ultimately the tribunal has to be satisfied are used necessarily to avoid serious harm or injustice to a person. So the first is what's known as an adult evidence order, and this can be used by the tribunal if it might not otherwise be able to obtain information from the adult in question. So they can essentially speak to the adult in the absence of anyone else in the hearing. The second is a closure order, which again, to avoid serious harm or injustice, can be used to exclude particular people, including active parties, from the hearing. There's also a non-publication order, which can be used outside of the general prohibition of identifying adults to prohibit the publication. And there's confidentiality orders, which can be used to withhold from a person, including an active party, a document or any information that the tribunal has before it. The Act also has a number of alternative substitute decision makers available under the Act. that could be considered before the appointment of a guardian or administrator. So firstly is informal basis, so relying on the adult's existing supports and networks. These decisions can be approved or ratified by the tribunal. There's a more formal basis, so there's an appointment under what's known as an enduring power of attorney, a statutory health attorney, and then there's the appointment of a guardian or administrator under the Act that we just spoke about. So that concludes my overview and discussion of Queensland's guardianship scheme. We'll have time for a question and answer shortly after Steve speaks. But for anyone who might have any questions or wish to potentially get some advice on guardianship and administration, please feel free to reach out to us on the details provided on the screen, and they'll also be shared with everyone. Queensland Advocacy for Inclusion is a free service. However, we can only assist people with disability and who are under the guardianship administration order or the application. If you're a family member or a supporter, then you may wish to still contact us and we can give you a relevant referral if that would be helpful. So thank you all very much.
Well, thank you very much, Dayne. That was a very interesting presentation. I'll now give a bit of information about the Disability Royal Commission and the specialist legal service that has been established to assist and support people engaging with the Royal Commission, which is Your Story Disability Legal Support. Firstly, a little bit about the Disability Royal Commission. It was established in April 2019, basically a response to very widespread reports of violence against and the neglect, abuse and exploitation of people with disability. The Royal Commission is investigating the mistreatment of people with disability, both past and present, in all contexts and settings. The Royal Commission defines disability very broadly, and it includes physical, intellectual, sensory, and psychosocial disability, but also people's struggles with mental health and serious illness. The Disability Royal Commission is gathering its information in a variety of different ways, through its own research, through public hearings, and through the personal experiences that people tell the Royal Commission about, through submissions, private sessions, and other forums. The Royal Commission will recommend ways to improve laws, policies, structures and practices to ensure a more inclusive and just society. And it will deliver its final report by 29 September 2023. Just have that next slide. So the Royal Commission wants to hear people's stories, and it wants to hear about them in all settings and context, although it is focusing on people with disability who have experienced mistreatment in schools, workplaces, jails and detention centres, forensic units and secure mental health facilities, group homes or boarding houses, family homes, hospitals and health facilities, and in the guardianship system, which we've been speaking about today. And there are a number of other topics that the Royal Commission has focused on, including in its public hearing program, which has been conducted throughout the country. Royal Commission is also focusing on the experiences of First Nations people with disability, women with disability, people with disability from multicultural communities, children and young people with disability, and LGBTIQA+ people with disability. Coming up in November in New South Wales, the Disability Royal Commission will be conducting its 30th public hearing, specifically on the topic of guardianship, substituted and supported decision making. So it's timely that we're talking about this issue today. We've confined it to Queensland because, as we mentioned before, the laws vary from state to state, but many of the principles will be relevant, and the Royal Commission is focusing on that topic through its public hearing. As I mentioned before, the laws in relation to guardianship and administration vary from state to state and from territory to territory, and may restrict how information about legal proceedings for guardianship and the administration of guardianship orders may be disclosed or published. And those laws may affect how someone shares their story with the Disability Royal Commission. And it's for that reason that we strongly advise anyone who's wishing to share their story or someone else's story about guardianship and administration to get advice from Your Story legal support about their own situation and safe ways to share your story. Our service, Your Story, provides free, confidential and independent legal advice and support to people under guardianship orders and their families, as well as more generally. We're a free national service. We have staff in every state and territory. Our legal advice is confidential for anyone thinking about sharing their story. We're completely independent of the Disability Royal Commission, and we can connect people with other supports, including free counselling and help with other legal matters. So how can I share my story with the Disability Royal Commission? Well, there's a number of different ways that it can be done. It can be done providing consent to the Royal Commission to publish or disclose parts of the story, or it can be done requesting the Royal Commission to keep all parts of your story private and confidential. So Your Story provides advice about safe ways to share your story with the Disability Royal Commission. And as I said, we can connect people with free counselling and advocacy support. The Royal Commission will accept people's stories in any language or in any format. It can be a submission in writing. It can be a submission delivered over the telephone, or it can be video or audio recorded, or indeed it could be a piece of art, and whether it be visual art or it could be a poem or some other form of, basically any way that a person can communicate their experience. The Disability Royal Commission will do its best to receive that. And the story can be about your own lived experience of disability, or it can be about someone else's experience, provided that that person has given their consent. And that's an example, a good example of a situation where someone may wish to get some legal advice if they're planning on sharing someone else's story. A very important date to remember, the closing date for submissions is the 31st of December 2022. So still a bit of time, but until the end of this year. So just to wrap it up, the Disability Royal Commission wants to hear stories and ideas for change from people with disability and their supporters, and that includes people under guardianship orders, their families, carers and guardians. Your Story is a free national service that gives independent legal advice and support to anyone thinking about sharing their story. And we can support people under guardianship orders and their families. And we would encourage people to contact us to get advice about their situation and safe ways to share your story. There are our contact details. You can telephone us 1800 771 800 or email us at yourstory.disability@legalaid.qld.gov.au, or you can check out our website, yourstory.disabilitylegal.org.au. Our website has got a range of really useful and informative information, and people may also wish, if they're interested, to visit the Disability Royal Commission website, which also has a range of resources and information. Okay, well, we've reached the point in our webinar today where we're going to answer some questions. Just a reminder, before we commence the Q&A session, that, as I've mentioned before, there are laws in each state and territory restricting information about guardianship proceedings, which may affect how you share your story with the Royal Commission. And so for that reason, we ask that today, please do not disclose any personal information about a person under a guardianship order or who has previously been involved in guardianship proceedings, either in your questions or at any time during the webinar. Okay, well, we'll go to our first question for Dayne. Dayne, how is capacity determined for decisions that have legal consequences?
Great question, Steve. Thank you very much, and thank you for your presentation. As I briefly mentioned during the discussion, capacity has a specific definition within the Act, and that is a person's ability to understand the nature and effect of the decision, make it freely and voluntarily, and then also communicate it in some way. It's also important to recognise that capacity is decision specific and domain specific as well. There's no one single test for capacity. It depends on the subject matter of the decision to be made. However, the courts impose a more stringent capacity requirement for some domains rather than others. It's long been recognised that there's requiring a degree, of mental soundness, but that's higher than that required to enter marriage into contract than it is for the making of a will, for example. So a guardian can be appointed for personal matters. So that's things like the provision of goods and services, which may be NDIS or accommodation. But a guardian can't be appointed for special personal matters, which include the making of a will or consenting to marriages, for example. So alternative action would need to be taken, such as an application to the Supreme Court for a statutory will, for example. So that's just something to consider as well. I think one of the resources that will be shared, a document that we produced with other stakeholders, the handbook for practitioners, might be helpful in that regard as well.
Thank you, Dayne. The next question we have is, what is the difference between QCAT and interstate civil and administrative tribunals, such as New South Wales Civil Administrative Tribunal?
That's another good question. Thank you. So QAI is a state-based service, so we only have experience within QCAT, or the Queensland Civil and Administrative Tribunal. However, it's my understanding that the other state CATs have similar jurisdiction over their relevant pieces of guardianship legislation. There's provision within the Guardianship and Administration Act in Queensland that applies for similar orders to be effectively registered with QCAT and treated as if it was made by QCAT. So that's something, but I couldn't comment too much more about any differences or similarities between the different tribunals.
The next question, is the public guardian the same as the public trustee?
Another very good question, and the answer is no, that they're not. They're similar in that they're both statutory entities, so they're performing a function on behalf of the state. The public guardian can be appointed as a guardian, so that's a personal decision maker. So accommodation decisions, service provision decisions, for example. It also offers other services and performs other functions outside of that, but it can only be appointed as a guardian, for example. Whereas the public trustee is also a statutory entity performing other functions, but can only be appointed as an administrator, which is a financial decision maker only. So help managing someone's money, for example.
Thank you, Dayne. The next question is, how does a person apply for a previously active party to be removed as an active party when it has become evident at the previous hearing that this person's motivations were self-interested?
It's another very good question, and I'm not sure if I'll be able to provide a satisfactory response, and would definitely encourage anyone that has concerns, I guess, around those issues to seek legal advice around ways in which they might be able to work with who's involved in the proceedings and what information is available. But the definition of active party, as I explained during the proceeding, is defined by the Act, and so those people are active parties for the purposes of the Act. I would question here whether or not that the applicant would potentially be another active party if in a subsequent proceeding. Just having regard to that definition, being an applicant is an active party. So I don't know if that person, for example, might have been appointed as guardian. So it's a bit hard to answer in the abstract, but yet there's a strict definition under the Act of who is considered an active party, and unless QCAT makes an order otherwise to join other people as well.
Thanks, Dayne. The next question is, when guardianship orders decisions are made, some people who are deaf may feel left out of the picture due to miscommunication issues. Perhaps the assigned interpreter doesn't fully understand the individual's responses. Most interpreters are good, yet there may be a few whom these individuals do not feel comfortable with. How can these issues be overcome?
Yeah, that's a very good question. I'm not sure if I have a particularly great answer, but I would hope that anyone who is engaging in these proceedings can contact a lawyer or an advocate or someone to get assistance at the hearing. Certainly it's work that QAI does, and where we can. And it's really important that everyone understands the proceeding itself, the material that's before it, and what's happening, but also and what information they wish to put forward in terms of their views and wishes, but also the consequences of the hearing and what decision the tribunal made. So I think having a constant line of communication with the particular individual, with the constant updates, would be a nice way to resolve that. you may also wish to potentially, I guess, raise issues from the outset with the case manager at QCAT, for example, just to make sure that things run smoothly. Yeah, so that's what I would suggest, is it's just anyone reaching out for advice and support if possible.
The next question was about slides and information that has been part of the presentation today, and whether it would be available on the QAI website. But all of the slides that have been presented today by Dayne and myself will be circulated to all participants, including a link to the recording. And I'll mention that again when we wrap up. The next question, Dayne, you may have already addressed this and I missed it, so apologies if you did. If we have a client who is seeking assistance to be taken off a guardianship order, can we refer these clients to QAI?
Yes, absolutely. Great. Another great question. Thank you, Steve. And yes, QAI, we're a specialist community legal service for people with disability in Queensland, and we're free. It's just all, of course, subject to our resourcing at the time. But yes, absolutely, please refer anyone who might be subject to a guardianship order or administration order and application to us, and we can assist. Yeah, as I said, we can't unfortunately assist you know, friends or family members who are trying to support the adult, but definitely the adult, we would really encourage that they reach out to us.
And Dayne, are you able to make any recommendations or suggestions about people who are in that category that can't be assisted by QAI, where they might get some further advice?
It's another great question. And there are other services out there that do, there's a limited number of services that I guess do this kind of work. Off the top of my head, I can think of another community legal service called ADA Law. There's also my understanding is the Law Right, which is another community legal service. They do a court and tribunal representation service as well, operating in QCAT. So there might be some other services out there that could assist people, but I would definitely encourage people to contact us if they would like in the first instance. And if we can't, then we will give them the contact details for those appropriate services.
Great, thanks, Dayne. Another question, perhaps more in the nature of a comment, is about the way that QCAT hears evidence and makes decisions, specifically that it's not bound by the rules of evidence. Do you want to make a comment about that, Dayne, how that differs from what we would otherwise describe as a court?
Yeah, it's a very good question, and I must say I don't have experience in working with courts, so to talk about the strict rules of evidence, but I guess it allows a bit more flexibility and yeah, accessibility for people engaging in the system in terms of what evidence they can put forward to the tribunal for it to consider in making an application and in considering a decision, in making a decision, sorry. I guess the opposite side of that is then that potentially information could be put forward that might not be as credible in support of an application, for example. However, it's the member's job to essentially scrutinise the evidence and ask questions of those people in attendance in its inquisitorial nature to satisfy itself or satisfy the member that the relevant criteria for the particular decision are met.
Thanks, Dayne. The question, Dayne, what paperwork makes getting guardianship easier? For example, is it necessary or better to have a formal diagnosis of a disability? And what are the alternatives to formal substitute decision makings?
Great question. And yeah, I guess it's certainly our position that you know, the appointment of a guardian or administrator is the last resort. So I don't know if I'd feel comfortable commenting on what makes those processes easier, because it is a very restrictive option for our clients and adults engaging in the system having your decision-making autonomy removed and replaced by a statutory entity like the public guardian, for example. There are rules, the QCAT rules, for example, that list particular requirements of applications for guardianship and administration, what's required to be contained in them and submitted with them. So again, depending on the circumstance, the relevant person might want to get some advice or consult the rules about what is required to be submitted. But yes, strongly encourage all other options to be considered for supported decision making. It's much more in line with the Convention on the Rights of Persons with Disability to approach it with a supported sense rather than a substituted sense. There are options, for example, you might want to speak with the particular entity involved, but you might be able to appoint someone as a signatory with your bank to help with money, or appoint someone as a contact at Centrelink, for example. There's also similar provisions in like the NDIS sphere as well to have supporters assist people with those particular decisions on an informal basis rather than a formal substituted decision-making basis.
Great, thanks, Dayne. And the last question that we're going to have time to ask today is about, the question is, if we encounter an NDIS participant who wants to alter their QCAT appointment, is QAI an appropriate organisation for us to direct them for guidance or advice?
Yeah, absolutely. That's a really great question, and absolutely, yes, that's something that we could assist, at least providing the person under the order with advice on about how they might go around applying for a review of the order, and who they might want to consider appointing as an alternative, for example. So yes, please do refer those people to us.
All right. Well, unfortunately, we don't have time for any more questions today. Any questions that have been posted or other useful information that we can share with participants that's relevant to today's webinars and questions will be circulated to participants. I'd like to thank Dayne very much for his insightful presentation and answering all of those questions. I'd also like to thank the support staff from Your Story Disability Legal Support and both organisations, QAI as well, who have assisted in preparing today's webinar and making sure that it runs smoothly. Just a couple of final points on the Royal Commission. A reminder that free support is available for people wanting to share their stories and ideas for change with the Disability Royal Commission. And also, at Your Story, we would love to hear from you. And you can our survey form that appears on the screen at the end of the webinar. A recording of today's webinar will be available on the Your Story Facebook page, and it'll also be added to YouTube in the coming weeks. And just a reminder that for anyone who wishes to share their experience with the Disability Royal Commission, writing or by the telephone, submissions do close on the 31st of December of this year. And also a reminder that the Disability Royal Commission is conducting a public hearing into guardianship and supported and substituted decision making. It is a key area of concern for the Royal Commission. And anyone who has been listening today to our webinar and participating in it may wish to consider whether they would like to make a submission before the closing date and encourage others to do so. Well, as the time has come for us to end today's webinar, I thank everyone for participating and thank you for your questions. Please complete our survey and look out for the recordings of the webinar that will be circulated to participants. It appears that we may not have been able to share the QR code on the screen that I mentioned, but we will circulate the survey and you can use the link that has now appeared in the chat. Thank you very much, everyone, for participating in today's webinar.
Thank you.